very distinguished reputation as counsel practicing in general civil litigation areas. He purports to restrict his practice to such erudite matters as constitutional law, administrative law and competition law. Would that we were all so lucky that we could make that proud boast. John Laskin's reputation is one for quiet and very persuasive argument. And you will understand therefore why we selected as his opponent Mr. Eric Murray. The last time I was permitted to introduce Eric Murray, I was not then his partner, it was some 5 years ago and he's never allowed me to do it since. I said, the next member of the panel is Eric Murray, who needs no introduction, and the next member of the panel is so-and-so. And he was furious because I said absolutely nothing about him. He may be even more furious if I introduce him more fully. And so I will not. I believe it was Dr. Johnson who said that a lawyer is one who sells his anger. If that be so, Murray must be the richest counsel in Canada. He has a wealth of indignation. He has a capacity for indignation. He thought today that he was going to be appearing for the plaintiff appellant, the party whom he originally perceived to be the wronged party. When he found, in fact, he was acting for the defendant respondent, he quickly recognized the merit of that party's case, and he's now persuaded irrevocably that he's acting for the innocent party once again. It promises to be an interesting exercise in contrasting styles. I no doubt Mr. Justice Megarry will encounter styles of advocacy with which he may not have been too familiar in the Chancery Division, but with which I have no doubt he will demonstrate an admirable capacity to cope. And it may be useful, I think, if before we begin the argument, David Roebuck briefly reminds you of the facts. It is, after all, 2 days since you saw them on television, and a brief synopsis might be helpful.
I know the video is riveted in your memory. The facts of our case are these. There was a meeting between a development company, Interurban, and a trust company, General Trust. Only after we recited the facts did we realize that there actually is a General Trust. So it's all fictional. And at the meeting, Interurban brings to a representative of General Trust, who is herself a solicitor, information concerning certain properties near the town of Bradford. Certain reports are put on the table which are marked as confidential. There is no express discussion about confidentiality, although Ms. Smith would probably concede that at that stage she would have recognized some element of confidentiality. Interurban wants to pursue residential development. General Trust is given the opportunity to go out and examine the lands for themselves. Ms. Smith gets a title search. She misreads the title search and believes that there are restrictions on the property which would prevent or severely limit their rezoning. And she therefore convenes a second meeting with Interurban, reports on her search, and General Trust declines to go forward with this transaction, which, had they accepted it, had an offer of a participation element, a right to, by putting up certain costs, share to a certain extent in the equity and the profits of the project. Sometime later, quite by accident, Ms. Smith hears that there is some activity in the Bradford area, and in particular that a Japanese automotive manufacturer may be interested in acquiring some property nearby for purposes of building a plant. She then recalls that when she looked at the title search, She noticed patterns of activity in the neighborhood. It was a pattern which she recognized and thought it could be potentially significant, but given her view as to the title matters, she did not take it forward, and she did not mention to the representative of Interurban that land activity. Now that she hears the rumor, she puts two and two together. She takes the matter to General Developments, which is a subsidiary in the real estate business of General Trust, and General Development goes out and acquires the lands because Ms. Smith finds that on a review of her file, the restrictions on the easements were not as severe as she had originally anticipated, and indeed would have been consistent with both commercial and residential development. An action is commenced by Interurban. It is an action seeking a number of remedies, but in particular, they want the land. They want the mine as in lack. The action goes to trial and represented by Mr. Laskin for the plaintiff, and is unsuccessful. After all, he was opposed by Mr. Murray, and now Mr. Laskin is going to be presenting his argument in appeal before my Lord Sir Robert Megarry, and he will be opposed by Mr. Murray, and if you draw near and give your attention, you shall be heard. Slightly because I know Mr. Megarry and
yeah,
at the
anything
edge of
like
it. Just don't want it to tumble over.
Yes, Mr. Laskin. I gather this is a case being tried on an agreed statement of facts. Well, I was supplied with an agreed statement of facts a day or two ago, and then I was supplied with another one 5 minutes ago. I propose to take the facts selectively from both, but there are parts of the new one that I don't understand. For example, Interurban had in mind a ballpark figure. That is an expression that I don't understand. And you need to explain to me.
Some would say the local baseball team doesn't understand.
So be it. But I shall take both as being expressions of agreement between the parties as to what the facts are.
Thank you, my lord.
Is that agreeable to you, Mr. Murray?
Well, I haven't read them, so...
I hand your lordship a book of authorities.
Thank you.
Now, my lord, as you know, I act for Interurban Inc., and I have 3 submissions to make on this appeal. Number 1, in my submission, the defendants are liable both for breach of confidence and breach of fiduciary duty in acquiring the Bradford properties, if I may refer to them as that, for their own benefit to the complete exclusion of the plaintiff. Now, of course, in my submission, should I succeed on either ground, I succeed in this case, but I argue that the defendants are liable for both breaches. Second, in the alternative...
Does it matter which?
In my respectful submission, it does not, my lord, although there is some issue as to the appropriate remedy depending upon the finding of breach.
So it suffices you if you get home on either?
Suffices that I get home on either, and I'll come to that. And then my second submission is, in the alternative, that the defendants are liable by reason of the breach by the Solicitor Smith of a special duty of care which I say she owed to the plaintiff, to my client, to make full and accurate disclosure of the facts. A duty which is at least akin to a fiduciary duty, and which in my submission she breached on the record. And then my third submission is that the appropriate remedy, and indeed I say the only just remedy for the defendant's conduct, is an injunction, first restraining the sale of the Bradford properties to the Japanese car manufacturer, and an order that those properties are held by way of constructive trust for the benefit of the plaintiff. Now, I want to deal with my first submission and first deal with what I submit as a clear case of breach of confidence. And your lordship will well know the essential elements of a cause of action for breach of confidence. You indeed set them forth, a case called Coco and Clark, which is at tab 1 of the Book of Authorities. And at page 47, listed the 3 elements as follows. Number 1, the information must be of a confidential nature. Second, it must be communicated in circumstances importing an obligation of confidence. And third, there must be an unauthorized use of that information to the detriment of the party communicating it. And let me deal briefly with each of those.
Is that of any authority in Canada?
Well, the Supreme Court of Canada in Laskin, Corona, both the majority and minority views, both adopted those principles, my lord. And I say they are well settled and well established not only in England but in this country.
Thank you.
Now, I say the information here is clearly confidential. It has the quality of confidence about it. And I make that submission over and above the fact that the documents are marked confidential. But I think what is important to understand in my submission is just what information I say is confidential. Contents of studies themselves that is confidential. The key information that's confidential, and indeed the heart of the plaintiff's case, is that the information that is confidential is the potential development opportunity for these properties. It's this ripening development opportunity which I say is confidential and which I say at the end of the day deserves the protection of this court. Now, the second element of the test was the information communicated in circumstances supporting an obligation of confidence. I can't think there's any doubt about it. I can't do better than quote what your lordship said, again in Coco and Clark at page 48. I might have your lordship turn to that at about line 13. You said, "It seems to me that if the circumstances are such that any reasonable man standing in the shoes of the recipient of the information would have realized that upon reasonable grounds the information was being given to him in confidence, then this should suffice to impose upon him the equitable obligation of confidence. In particular, where information of commercial or industrial value is given on a business-like basis and some avowed common object in mind, such as a joint venture or the manufacture of articles by one party for the other, I would regard the recipient as carrying a heavy burden if he seeks to repel a contention that he was bound by an obligation of confidence. Now, my Lord, that is precisely our case, and the evidence, indeed, of Miss Smith herself effectively acknowledges that. She said that one takes it at that. That is, one takes it that the information is confidential, and that's at paragraph 4 of the second document which Your Lordship looked at. She acknowledged that the information could have been regarded as confidential at the time, as being imparted to her on a confidential basis. So I say there can't really be any doubt about the second element. And that brings me to the third element, and that is, I say the defendants had a duty not to use this information for any purpose other than that for which it was conveyed. Now, what was it conveyed for? It was conveyed, I say, to permit the defendants to investigate the giving of mortgage assistance to the plaintiff, or to permit the defendants to become equity partners. The one thing the defendants could not do is take the information and use it for their own account. And yet I say that is precisely what they did. Now, the defendants have tried to evade responsibility by claiming my clients were interested in a residential development and the defendants did a totally different deal. This is a new ball game, we're in a new ballpark, and so on. And I say that distinction affords the defendants no relief on this record. The confidential information given to the defendants was, to use some of the language of the cases, the springboard for their subsequent activity. That was the trigger in her own mind. You will recall Ms. Smith's own evidence. When she heard about the land assembly in Bradford from her client, from a third party, she said, I put 2 and 2 together, and I got 4. It's worth taking a second look. Well, part of that equation, the first 2 of the 2 and 2 together, was the earlier confidential information from the plaintiff. She went back to her file, and as a result of that, followed up on the acquisition. And I say it does not lie in the defendant's mouth to seek to escape liability from drawing this fine distinction between residential and industrial. It's, after all, the ripening development opportunity of this property that is key. And I say, but for the earlier information from Interurban, the subsequent comment from the client would have not provoked the defendant's interest. The law should not countenance this kind of excuse because it's too easy. It's too easy for defendants, such as those represented by my learned friend, to escape proper liability by relying on excuses like that. Now, the last part of the test, was it to the detriment of the plaintiff? I say it was. The plaintiff had not abandoned its desire for this property. It had put it on hold, and only because it had been given misinformation by Ms. Smith. That's the only reason they put this project on hold. And so I say by its conduct, the defendant had put it beyond the plaintiff's power to acquire this property that it was very interested in. And I say, for those reasons, there is a clear breach which must be rectified. Now, I want to come to the second point, and that is whether there is a breach of fiduciary duty. And Your Lordship will appreciate that in this country, perhaps unlike in England, there have been a plethora of cases on a breach of fiduciary duty lately, in all sorts of circumstances. I readily acknowledge, my Lord, that this is not one of the traditional categories of fiduciary duty. It's not a trustee and Seneca trust. It's not a solicitor and client and so forth. And I also acknowledge that fiduciary duties are not generally imposed by courts in the context of ordinary commercial dealings. But courts in this country have recognized that the categories of fiduciary duties are not closed, and that a fiduciary obligation can arise out of the specific circumstances of a relationship. And really, as former Chief Justice Dixon said, it is the nature of the relationship that is critical. And I say this is one of these cases in which this court can properly and fairly impose a fiduciary obligation. And may I put it this way? The central issue, I say, is whether the plaintiff interurban could reasonably expect that the defendant would refrain from acting contrary to its interest with respect to the confidential information it received from the plaintiff. And when one puts the question that way, as I say it must be, the answer in my respectful submission can only be yes. There is a fiduciary duty here on the part of the defendants with respect to the confidential information not to use it for their own benefit. And
what is it to which the fiduciary duty applies? You say it's the information.
Yes, in my respectful submission, it's the information, and you'll recall that the thrust of my submission is the key information is the fact of this opportunity for future development on these lands. That's what, in reality, the defendants were made aware of in these two meetings that took place with the plaintiff.
Are you saying that that information is property?
I'm not saying it's property per se, but I am saying that it is one of the factors that can give rise to a fiduciary duty, and it can, at the end of the day, lead to a remedy, and I'm going to come to this, can lead to a remedy that is effectively proprietary in nature. In my submission, one doesn't need to get into the debate as to whether confidential information is property or not property. One can look at it on equitable grounds in terms of remedy, as I'll come to, and impose the appropriate equitable relief.
You're not proposing to work back from the remedy.
I'm not proposing...
And say, therefore, there is a fiduciary obligation.
Well, as I recall, your lordship warned against that in a case called Tito and Waddell, so that I'm not going to try and work back from the remedy. I'm trying to work forward from the pre-existing duty, if I may put it that way. And I want to just pause for a moment to tell your lordship why I say the duties here. I say the duties here because of two key facts. First of all, the information was, I say, given in circumstances of trust and confidence. Now, your lordship will recall and know that, of course, fiduciary obligations historically arose out of the notion of breach of confidence. So I say that's a very important factor that the court can look at in determining whether there are fiduciary obligations here. But that's not all. That's not all. There's a second factor, and one that seems to have commended itself to the judges of our Supreme Court of Canada and to a number of the academic writers on the subject, and that is the factor of vulnerability. Was the plaintiff vulnerable at the exercise of the discretion of the defendants, at the hands of the defendants? I say it was. I say it was because the plaintiff's financial resources were stretched. It was looking to and dependent on the defendant for financing. In that context, it gave to the defendant for its own use and inquiry confidential information about the development potential of these lands and the plaintiff's interest and intent to acquire the lands.
Are you saying that if someone is looking for finance, they're vulnerable?
No, not in and of itself. Not in and of itself, my lord, but if you take that, you see, it's really the combination of that in conjunction with, and not just looking for financing. This is a company, my client, whose finances were stretched. But that, I would acknowledge, is not enough in and of itself. But you've got to marry that, I say. You have to marry that to the fact that the plaintiff said, here, we need your help, defendant. We need your assistance. We're going to give you this information that's confidential, and we're going to tell you that we want to get these lands. We want to acquire these lands. Now, you go off and make your own investigations. That left the plaintiff vulnerable to the very harm that the defendant ultimately inflicted. And I say that gives rise to a fiduciary obligation. The defendants breached it. This is a strict duty. This is equity. They cannot benefit. They have a strict duty of loyalty. And I say I don't even have to prove detriment in this case. I don't have to prove harm. There has been a breach by reason of the fact that the defendant has used the information for its own benefit to the complete exclusion.
There's a difference between a rich company and a poor company. The poor is vulnerable, the rich is not.
It may be. It may well be, my lord, and in my respectful submission, Mr. Justice Laforêt in Laskin Corona placed some emphasis on that fact. It wasn't so much rich and poor, but the resources of Corona vis-a-vis the resources of Lac. Corona was a junior mining company and so forth. These are all facts which I say go to the question of vulnerability.
You say not rich and poor, but big and small.
Well, could be. It could be big and small. But let me, my lord, if I might turn briefly to the second submission that I made, and that is, and this is really an alternative submission, because if I succeed on my first submission, I say I'm entitled to the remedy of constructive trust. So this is an alternative submission, and the alternative submission puts a special duty of care on the solicitor, Miss Smith, which I say she breached. Now, let me say at the outset, I'm not for a moment suggesting that Miss Smith acted in bad faith. No, there's no allegation and no finding of bad faith here. I'm not saying she deliberately withheld information. Nor am I suggesting that she was Interurban's solicitor. Clearly she wasn't. She wasn't acting for Interurban. She was acting for the defendants. But I say that neither of those factors absolves her from liability, because she, as a solicitor, possessing special skills, undertook to investigate the property, the Bradford property, for the purpose of assisting or joining the plaintiff in this deal. And when she came back to report to the plaintiff, I say she owed the plaintiff a special duty of care akin to a fiduciary duty. In fact, some of our judges have termed it, aptly in my submission, a quasi-fiduciary obligation. I thought that might trouble your lordship, but I assure you...
Quasi-fiduciary.
Quasi-fiduciary duty. And there are several judges of our High Court who have so called that obligation. But one needn't call it that, my lord. It is a special duty of care, if you will, in the Hedley, Byrne, and Heller sense. So that when she came back to report, because she knew that the plaintiff was relying upon what she was going to say, and she never qualified what she said, it seemed to me she had to do the following three things, none of which she did. Number one, she had to make full disclosure. She had to disclose the fact of recent acquisitions of surrounding lands. And while she didn't deliberately withhold it, that's not enough. She had a duty to disclose it, and she was careless, and she didn't do it. Second, because her duty is ongoing, if I'm correct, she had to correct the misinformation concerning the impact of the easements. She left my client with a thoroughly mistaken impression of future development on that property, and it's the whole reason my client didn't go ahead with the property. And so I say she had a duty to come back and correct that misinformation. And lastly, I say she had a duty to disclose the subsequent information she received concerning the Japanese car manufacturer.
Well, for a while, the whole thing went dead, didn't it? After her report about these easements over the land, it was dropped on both sides.
It was absolutely dropped on both sides, but the reason it was dropped on my client's side...
Do these obligations survive the drop?
Well, in my respectful submission, they do, and I say that for two reasons. Number one, I say that the reason that the matter dropped from my client's point of view was that she gave us the wrong information. So she can't turn around and say, oh, well, the thing stopped, this is a whole new deal, because she was the whole reason through the communication of her misinformation that the matter stopped. And secondly, as our courts have recognized in cases like Canaro and O'Malley, fiduciary type obligations or special type duties of care can continue on. So I say the obligation continues, and what I really say is that she did the one thing that she couldn't do. She told part of the story to the plaintiff not the whole story, part of the story, and the part she told she got wrong, and then she never had the decency to come back and correct it. And in my respectful submission, because of that, she is liable, and so is her employer as a result, because she's just an employee, and her employer becomes liable for the breach.
She only told part, and that was wrong.
And the part she told was wrong,
And the other part she never told.
and the other part she never told.
Yeah, that's it.
And then, may I lastly, and I appreciate that the time is short, may I lastly and very briefly address remedy. The law in my...
Well, you needn't apologize for taking time. You've had some assistance from the court.
Well, I always appreciate that. May I say this on remedy, and I will be brief. I say the law is clear. Your Lordship can grant an injunction and a constructive trust, and your Lordship can do it either for breach of confidence or breach of fiduciary duty. It is to the court to decide if it is the just and appropriate remedy, and I say it is. And I say it is for three reasons, and I give them to you briefly, and then I will sit down. Number one, because that remedy and that remedy alone will prevent the wrongdoer, here the defendants, from benefiting from their wrong. No other remedy will achieve that object. Second, no other remedy will advance what I say is the proper business ethic and morality that this court should approve of, because to do otherwise, to give only damages, to give the defendant some interest in this property, is simply an encouragement to the kind of behavior that these defendants engaged in, and I say the court should not fashion a remedy that will do that. And then lastly...
But haven't the defendants sold this land?
They have not sold it yet, and one of the things I am seeking is an injunction to restrain it.
Yes.
Which facts does my lord have?
I'm sorry?
Which version of the facts does my lord have?
Well, I'm not sure. Why I was making the inquiry of counsel.
I think Mr. Murray's client, as I recall the evidence, my lord, has an attractive offer, a very nice offer, according to Ms. Smith, from the Japanese car manufacturer, which it is considering. But Ms. Smith, in an exercise of some prudence, decided to consult Mr. Murray before recommending to her board of directors that this offer go forward. And I believe those are the facts on the record.
Yes. Thank you.
And so I say that, and I say the last reason, my lord, why you should order a constructive trust and an injunction is that because only that remedy will redirect the property to the party that is properly entitled to it and was pursuing it in the first place. That is my client. In other words, only that remedy will give effect to the intent of the parties. I'm obliged to my lord. Those are my respectful
Yes,
statements.
thank you, Mr. Laskin. Mr. Murray.
Yes.
Court will adjourn for 30 seconds. Well, Mr. Murray, after the conclusion of the thunder, you may now begin.
Well, my lord, I am cognizant of the fact that my lord has limited our argument to 20-odd minutes, which my friend has so grossly abused, because my lord has a golf game at 5:30, and therefore I am not in a position to go into the law in depth. I regret your lordship has not had an opportunity to read my factum, which took 3 days to prepare. I will nonetheless try firstly to summarize the significant facts which should have put an end to the whole matter. But listening to Mr. Laskin, my lord, I really feel we've crashed through the looking glass, fallen down the rabbit hole, and we're at the Mad Hatter's tea party. The significant facts are as follows. One, the plaintiff is a sophisticated land developer which has its own lawyers, engineers, planners, and consultants. 2, the plaintiff's studies of the 3 parcels of land most assuredly must contain a detailed title search, probably much more comprehensive than was done by Ms. Smith. 3, the project the plaintiff sought financing for with a future option for participation was for the development of agricultural land into residential subdivisions. 4, Ms. Smith investigated the proposal, made an honest mistake about title. As a result of her own investigations on behalf of her employer, General, she detected activity and recent purchases in the area. Of no particular significance considering what happened. As Ms. Smith advised Interurban about the title problems, although she was under no obligation to do so, she said that she had found these defects in title.
Wasn't there an agreement that she would investigate and look into the title?
No, that's not an agreement between the parties. They invited her to look into title, which naturally she would do in any event on behalf of her own employer. It wasn't an invitation to act on their behalf.
It wasn't an agreement, it was a disagreement, was it?
It wasn't an agreement at all. It was a suggestion, why don't you have a look at the title? Well, naturally she was going to look at the title anyway, which is precisely what she did. She wasn't doing it for them. They'd already done it.
Had they?
Oh, well, what are they doing sitting there with 3 confidential reports stamped confidential with planners and engineers? Obviously they looked at the title of the property.
Well, I don't remember reading that in any of the versions of the facts.
Well, my lord, I have a 4th version.
Yes, Mr. Mayor.
And she incidentally detected activity in recent purchases in the area, which of course one can gather my learned friend's clients knew all about as well. And she advised them of the title problem, and they elected to do nothing about it. Nothing. They must have either known about the easements, and if not, why didn't they go and have them checked out? Yet Mr. Laskin says the whole reason that the plaintiff didn't go ahead was because Ms. Smith, the solicitor for General, told them their title wasn't any good.
Are you arguing contributory negligence?
Well, it sounds like the Negligence Act, my lord. I don't know, but my friend is arguing this either in contract or in breach of some fiduciary duty, and now he's launched into converting our solicitor into his solicitor, and presumably she was negligent in giving him advice.
Thank you.
Ms. Smith returned the 3 residential studies, which were marked confidential, and never saw them again. The proposal was over. Ms. Smith learned through a client later on the rumor of Toyota building in the Bradford area and industrial development. And after brushing off the file, looking at it and determining her title mistake, concluded that the land, which incidentally included the interurban parcels as a part of this parcel, were ripe for industrial speculation. And this was the springboard. This information from the client was the springboard or trigger for General in proceeding into the acquisition of these lands. And they did in fact acquire them for industrial speculation. There is no evidence that the township would have allowed a residential rezoning, nor any evidence that the reports marked confidential contained confidential material. I'm sure my lord needs no authority for the proposition that you cannot make something confidential just by so designating it. My lord, think of the litigation chaos that would result if it were otherwise. For example, if the Gideon Society began marking its Bibles as this confidential, can my lord imagine what would happen? There is no evidence that General would have participated in Interurban's proposal even if the title problem had not existed. Nor is there any evidence. Think, my lord, just because there was a title problem, that there was a mistake, that didn't mean General would have gone ahead if it had learned that if the title search had been correct. Nor is there any evidence that Interurban, in its precarious financial position, could have proceeded unless a participation was eventually agreed to by General. There is no suggestion of fraud or malafides in General's refusal to participate with General. When General declined the deal was dead, and General had no intention of acquiring any interest in the lands in question. It was all over. There are no documents or correspondence of any nature or kind indicating a fiduciary relationship between anyone, or that Interurban was in any way relying on General or Miss Smith for advice or counsel. One would have thought, my lord, that those facts would have ended the matter, but Mr. Laskin characteristically plows ahead and plows into two main issues. One, was there a fiduciary relationship? Two, was there a misuse of confidential information? So I'll deal with them under those headings. Was there a fiduciary relationship between anybody? Corona and Lack says no. And surely the facts in this case are far more, the facts in that case, the Lack and Corona case, are far more conducive to a finding of a fiduciary relationship. And it does not advance the plaintiff's argument to any noticeable degree by relying on dissenting opinions. In Corona and Lack, Mr. Justice Sapinka specifically rejected the findings in the courts below that a fiduciary relationship arose between the parties. And he held, inter alia, 1. The consequences attendant on a finding of a fiduciary relationship and its breach have resulted in judicial reluctance to do so, except where the application of this, quote, blunt tool of equity, close quote, is necessary. 2, it is rare that it is required in the context of an arm's-length commercial transaction, and he adopted the words of Mr. Justice Kenny in his text. It would seem that part of the reluctance to find a fiduciary duty within an arm's-length commercial transaction is due to the fact that the parties in that situation have an adequate opportunity to prescribe their mutual obligations, and that the contractual remedies available to them to obtain compensation for any breach of those obligations should be sufficient. He goes on, my lord, to adopt the words of Mr. Justice Dawson in the Hospital Products Limited case. The undesirability of extending fiduciary duties to commercial relationships and the anomaly of imposing those duties where the parties are at arm's length from one another was referred to in the Weinberg case in the United States and in Barnes versus Addy, with which my lord is no doubt familiar, where Lord Selborne said, it is equally important to maintain the doctrine of trusts which is established in this court and not to strain it by unreasonable construction beyond its due and proper limits. There would be no better mode of undermining the sound doctrines of equity than to make unreasonable and inequitable applications of them. And finally, again in the same case, there is, however, the notion underlining all the cases of fiduciary obligation that inherent in the nature of the relationship itself is a position of disadvantage or vulnerability on the part of one of the parties which causes him to place reliance upon the other and requires the protection of equity acting upon the conscience of that other. And that perhaps, my lord, explains my lord's interjection to my friend's vulnerability argument. A sophisticated land developer, and if he can't get money from General, there's a million other finance companies he could have gone to. He wasn't vulnerable.
The poor little property developer.
That's the one, all of a sudden. The plaintiff had its own lawyers, engineers, and planners. How can it plausibly be argued it was in the position of disadvantage or vulnerability requiring the court to impose a non-existent fiduciary relationship by a blunt tool of equity? The courts, my lord, do not create a fiduciary relationship in order to grant an equitable remedy. As was said in the incredibly tedious 194 judgment in Tito versus Waddell No. 2, a decision.
How many pages?
194, my lord.
I beg your pardon?
That was a decision, my lord, by Mr. Justice Megarry dealing with Fiji Islanders, as they now are.
I recognize the case, but I think the number of pages are you...
I have counted them, my lord, and I have the case, of course.
Well,
if your lordship would like to take a few minutes to read it, this is double indexed.
Yes. But out of that you extract?
At page 232, the learned judge said, if there is a fiduciary, the equitable rules about self-dealing apply. But self-dealing does not impose the duty. Equity bases its rules about self-dealing on some pre-existing fiduciary duty. It is a disregard of this pre-existing duty that subjects the self-dealer to the consequences of the self-dealing rules. I do not think that one can take a person who is subject to no pre-existing fiduciary duty and then say that because he self-deals, he is thereupon subjected to a fiduciary duty. My lord already raised that point with my friend. Now, this proposition was put far more eloquently in the recent Alberta case of Northland Bank versus Kelcher et al., where Master Funduck held. My lord, I really don't wish to be accused of making up names. I have the case here. It was just released this week. And the master there said, the defendants jump in by alleging a breach of fiduciary duty. Before there can be a breach of fiduciary duty, there must be a fiduciary duty. There cannot be a breach of a duty if there is no duty.
But certainly put with greater brevity.
Thank you. In this case, my lord, there was a total absence of fraud in the declaration by General of the proposition to finance or finance with an interest. Certainly there was an honest mistake by the lovely English solicitor, Miss Smith, in reporting to her employer the defect in title, which cannot constitute fraud or malafides. 2, Smith was never a solicitor for Interurban. She was employed by General, gave her opinion to General, and was never retained by Interurban and never gave any legal advice to or performed any services for it. If my friend really suggests that Miss Smith searched the title for the benefit of Interurban, we should have counterclaimed for legal fees. Now, my friend has the case of Tracy...
You haven't done that, have you? It's a little late to do it now.
Well, our rules here are very flexible. In my friend's brief of authorities, he relies on the case of Tracy and Atkins in British Columbia, but doesn't draw to your lordship's attention that there was a finding of fact that the plaintiffs were unsophisticated vendors who relied on the defendant's solicitor to perform certain duties and to protect their interests. No such finding is made here, nor is it possible. So the whole case comes down to whether the defendant used confidential information. And the Supreme Court of Canada in Corona and Lack accepted in that case, based on extensive evidence of industry practice, that the information given to the defendant was confidential and that the defendant was in breach of its duty of confidence. It is significant in this case that my friend called no evidence of industry practice, and it is an irresistible conclusion that the empty witness chair is because any evidence from the industry would be dead against the plaintiff. There was no use of confidential information by the defendant. Furthermore, any information common to both the residential and industrial projects was public knowledge obtained by anyone who wished to take a peek at the records in the registry office. The allegedly confidential engineering and planning reports not only had been returned to Interurban, but those reports dealt exclusively with redeveloping part of the subsequently acquired lands for a residential subdivision. That was the purpose of the proposed financing. It had nothing to do with speculative industrial acquisition and played no part whatsoever in General's decision to make that acquisition. my lord, had General subsequently acquired these lands for redevelopment as a residential subdivision, it might cause us some difficulty in arguing that it had not used confidential information, assuming, of course, that the information was, or some portion of it was confidential. But any information in this particular instance that might be attributed to the meeting between the parties was readily available. It wasn't in the 3 confidential reports, it was in the registry office. And what then is the situation if a fresh initiative from some other source leads General to conclude the lands are ripe for speculation as industrial lands? My friend cleverly avoided the case of Canadian Aero Service Limited versus O'Malley et al. In the Supreme Court of Canada, which supplies the answer. Mr. Justice Laskin delivered the judgment before he became Chief Justice of Canada. He was, my lord, undoubtedly the foremost equity judge Canada has ever been blessed with, and it is to be regretted that he was unable to pass his deep grasp of equitable principles on to his son. Could my lord have opposing counsel desist from laughing during my argument?
Which makes Mr. Laskin's abilities all the more meritorious.
In the Canero case, the president and vice president of the plaintiff company negotiated on behalf of the company the acquisition of a project in Guyana. That used to be British Guiana, my lord. Those officers resigned from the plaintiff company in order to acquire the Guyana project for themselves. Mr. Justice Laskin held that those officers, that is the president and vice president, even though it was of a subsidiary of the company, stood in a fiduciary relationship with the company, not our case. But even in a fiduciary capacity, he had this to say at page 382. My lord, I ask you to listen very carefully to this. In my opinion, this ethic disqualifies a director or senior officer from usurping for himself or diverting to another person or company with whom or with which he is associated a maturing business opportunity which his company is actively pursuing. He is also precluded from so acting even after his resignation, where the resignation may fairly be said to have been prompted or influenced by a wish to acquire for himself the opportunity sought by the company. That's quite a caveat in himself, my lord, but listen to the next one. Or where it was his position with the company rather than a fresh initiative that led him to the opportunity which he later acquired. And I stress the words, my lord, fresh initiative. So even where there is a fiduciary relationship, an acquisition, a later acquisition, is not barred if it arises from a fresh initiative. Can there be anything clearer in this case that it was a fresh initiative based on a rumor from a client that led to the acquisition of these lands for an industrial speculative purpose rather than for residential redevelopment? The issue was dead as a doornail until the entirely new and different information came to hand. Now, my lord, my friend has also not drawn to your attention the case of Newport Resources versus Eustis, a trial decision of Mr. Justice Katzmann before his well-elevated elevation, and in which eminent counsel appeared for the defendants. And it is, my lord, directly on point. It was a case of a failed joint venture. Well, that's not on point, but that takes it even beyond our situation. A failed joint venture. They were in a joint venture. It had to do with mining property. And one of the, or actually two of the three, after the failed joint venture, then proceeded to make an acquisition. And Mr. Harquail, the other odd man out, was unhappy about that, so he sued. And Mr. Justice Katzmann dealt with the problem of misuses of confidential information at page 310. I'm not going to be that much longer, but I have a long quotation that I've asked my lord, to absorb. Mr. Moran's next submission, which he advanced both in association with the concept of joint venture and independently, may for convenience be termed misuse of confidential information. The proposition he put forward was that where one party gives information that is confidential to another, the other party may not use... Sorry, my lord, it might be easier. I just brought a copy for you. I don't have a copy from my friend. He submitted... I'm sorry. The other party may not use that information to gain an advantage without the consent of the person from whom he acquired it. I'm at about the 7th line down in the yellowed portion. He submitted that the information did not have to be labeled or expressed to be confidential if, in the circumstances, the reasonable recipient would understand it to have that character. When asked in argument what confidential information in his submission Harquail imparted to the defendants, in his he indicated that it was the fact that there was a defunct company called Consolidated Montclair that owned valuable property along the Pipestone Fault that appeared ripe for reactivation. Very similar to our case, my lord. Which was, he submitted, information that the defendants did not know until Harquail, the plaintiff, told them about it. Information they did not get from the public domain or from Montclair, but only from the plaintiff who gave it to them in confidence. My lord may have trouble finding the distinction between what my friend has alleged and the facts of this case. With respect, I do not consider the information identified by Mr. Moran to be confidential within the contemplation of the law. The evidence obtained on this point, which I accept, makes clear that none of the reports, memoranda, plans, maps, logs, or other documents or information which Montclair freely made available to Harquail and indeed to other inquirers between 1973 and 1980 was or was intended to be treated as confidential. The situation, in my view, comparable to that considered by the Alberta Court of Appeal in the Ridgewood Resources case, in which, affirming a trial judgment, it was said, pages 75 to 76, quote, "In my opinion, this appeal must fail in any event because the information transmitted by Miles to Hunnasett was not secret. It was in the public domain. During the course of argument, it was contended that though the information is not secret, the circumstances of disclosure may nevertheless produce a confidential relationship which makes the recipient liable for subsequent use to the detriment of the giver of the information. In my view, that is not a correct statement of the law. Both elements, secrecy of the information and the circumstances of confidential disclosure, must coexist. In addition, to render the cause of action complete, there must, of course, be an authorized use of the information to the detriment of the party giving the information, and he therefore rejected the claim. And to the same effect, my lord, see the case of Coco versus A.N. Clark, which, although a decision of an English court, is nonetheless of some persuasive value, since it was referred to, as my friend stated, in Corona and Lack. And my friend failed to tell you in that case that Mr. Justice Megarry, as he then was, held that release by one party of information in the public domain cannot subsequently give rise to an action for misuse of confidential information. In that case, unlike Corona and Lack, the information was substantially similar to information in the public domain. Here, of course, it was the same as in the public domain. And in Corona and Lack, only Corona had the information. My friend would have us believe, my lord, that if he should remark to me one day that he's thinking of buying a nice house at 75 Forest Hill Road, and I wander up that street and see a for sale sign on the property, I am precluded from buying it because, one, I am a fiduciary, or in any event, I would be using confidential information. My lord, my client performed a great service to Interurban. Can you imagine how many houses the plaintiff would have sold with an industrial park, auto park, on its doorstep, emitting noxious fumes and noises amid utter chaos? I note, my lord, that my time is up. and that if I deal with remedies, your lordship will be restricted to 9 holes. Because there is, in my always humble submission, not a tittle of merit to my friend's argument. The issue of remedies, I submit, is moot, and I will not deal with it. But, my lord, in view of the scandalous allegations in the pleadings and assertions by my friend before you, I am prepared to argue that costs as between a solicitor and his very own client should be awarded to the defendants. Thank you, Lord.
Yes, thank you. Yes, Mr. Laskin.
I have no reply.
The facts in this case lie in a narrow compass, and I'm indebted to counsel for confining their submissions in a very concise way. The facts, I think, are essential to an understanding of the problems that they give rise to in law. The company, Plaintiff Company, Interurban, is a builder and developer in the metropolitan Toronto area, acquiring land within 50 miles radius for residential development. The Plaintiff Company commissioned studies of the land for development, land that would be available for development within that 50 miles area. And in the end, they got 3 reports about parcels of land at Bradford in Ontario. Land which appeared to those making the report to have real potential for residential development. The Plaintiff Company, needing finance, approached the first defendant, General Trust, and had meetings with the third defendant, the General Counsel and the Secretary of General Trust. And they gave the third defendant copies of these 3 reports. The copies were either marked confidential or else were marked private and confidential. I do not think that that question of fact agreed, both statements of fact being agreed, I don't think that that makes any real difference. The reports were considered by the third defendant, who is the General Counsel and Secretary of General Trust, and the plaintiffs asked her to investigate the matter and to look into the title, which she agreed to do. The object was some joint venture in financing and developing this land, and there was some discussion of the terms upon which General Trust and its subsidiary General Development would take part in the scheme if the land proved ripe for development. There was, I think, some option to take an interest. Now, the third defendant conducted searches for the 3 plots of land and investigated them and the surrounding land as well. And in doing this, she discovered that there had been recent purchases of land in that area and other activities to suggest that it was not merely inert land, but land which was a subject of interest on people who might be going to buy it or develop it. The searches she found rather more disappointing, because they suggested to her that the 3 parcels of land which had been put before her by the plaintiff was subject to easements which would restrict residential development. In those circumstances, she reported the findings on the title to the directors of her company, General Trust, and recommended General Trust not to proceed with any arrangement with Interurban, the plaintiffs. She reported the title findings, the awkwardness of the easements, reported that to Interurban, the plaintiff. But she said nothing to them about the activities in relation to the surrounding land. So she returned the 3 reports to Interurban, still being marked, presumably, private and confidential or simply confidential. At that stage, everything came to a halt. General Trust broke off the discussions. Interurban gave up the scheme and investigated the possibility of buying the Bradford lands no longer. And so a point of repose was reached in the case. Whether it was a point of repose or a point of abandonment may be another matter. There was a new development about a month later. Miss Smith heard a rumor from some client that Japanese automobile manufacturers might be interested in building a plant in the Bradford area. And that, of course, struck a chord in her mind that the assembly of lands, the interest of possible purchasers in lands in the Bradford area might be due to the Japanese enterprise. She then also considered that it was possible that there might be a rezoning of that land for industrial purposes. And of course, at that, she got out her files again to have a look at them. And in doing that, she had another look at the searches and realized that she had misconstrued the ambit of these easements and that they were not so inimical to development as she had previously thought. That was all, of course, duly reported to her clients, to General Trust and General Development. And not a word of this was said to Interurban. The not unexpected result was that General Trust, through General Development's subsidiary, bought the 3 parcels of land and some abutting lands as well. And hardly had they done that when the Japanese promptly made an offer to buy the lands from General Development at a substantially higher price than had been paid for them. General Development then, presumably to get a better offer if possible, considered the offer that had been made. It then came to the knowledge of the plaintiffs that this is what had been done. And accordingly, the plaintiffs then issued a writ against all 3 defendants, claiming as relief, first, an injunction against the 2 companies restraining the sale of the lands to the Japanese car manufacturer or anyone else. Second, an order that the 2 companies should hold the Bradford properties by way of constructive trust for the benefit of the plaintiff. And third, in the alternative, damages against all defendants for breach of confidence, breach of fiduciary duty, and, in the case of Miss Smith, breach of a duty of care. Now, those facts have given rise to an interesting and not altogether easy argument. Mr. Laskin, who's appeared on behalf of the plaintiff, primarily bases himself on a misuse of confidential information. He has relied upon the 3 elements of confidentiality which were set out in a case called Cocoa against A.M. Clark Engineers Limited, 1969, Reports of Patent Cases, page 41. This contains statements which were adopted or approved by the Supreme Court of Canada in the Lack case, Lack Minerals Limited against International Corona Resources Limited, 1989, 61 Dominion Law Reports, 4th, page 14. The Cocoa case not merely dealt with what were the attributes of confidentiality, but also with the burden of proof. The attributes of confidentiality, put shortly, were that the information itself must have the necessary quality of confidence about it. Second, the information must have been imparted in circumstances importing an obligation of confidence. Third, there must be an unauthorized use of that information to the detriment of the party communicating it. Now, in this case, what was the confidential information? It concerned these three plots of land which were thought to have possible development potential. What was in mind, what was in the plaintiff's mind, was residential development. And a good deal of emphasis has been placed by Mr. Murray on the fact that residential development is substantially different from industrial development, and one can see that. At the same time, it seems to me that when one's concerned with land and dealings in land, dealings which often result in the sale of a purchase at a profit to someone else, it does not matter greatly whether the land is going to be developed for residential purposes or industrial purposes. What interests the purchaser is that it is more valuable than the price that he paid for it. And so I think it suffices if there is a potentiality of development. Seems to me that the information in this case has the necessary quality of confidence about it. If it was not a confidential matter, then it would mean that those concerned might tell third parties, and third parties might purchase the land instead and frustrate the whole enterprise. So it seems to me it is information with the necessary quality of confidence, and that it would have that quality irrespective of what the report said on the outside as being confidential and so on. The second question was whether it was imparted in circumstances importing an obligation of confidence. If one person goes to another with some project for development to their mutual advantage, a project that may be brought to naught if it becomes known to other people, then almost certainly, it seems to me, there are circumstances which import an obligation of confidence. Mr. Laskin relied upon another passage in Coco and Clark at page 48, which also had the advantage of some measure of approval by the Supreme Court of Canada in the Lack case. It seems to me if the circumstances are such that any reasonable man standing in the shoes of the recipient of the information would have realized that upon reasonable grounds the information was being given to him in confidence, then this should suffice to impose upon him the equitable obligation of confidence. In particular, where information of commercial or industrial value is given on a business-like basis and with some avowed common object in mind, such as a joint venture or the manufacture of articles by one party for the other, I would regard the recipient as carrying a heavy burden if he seeks to repel a contention that he was bound by an obligation of confidence. Now, in this case, a reasonable man in the shoes of the recipient must surely have realized that the information being given was information of commercial or industrial value being given on a business-like basis with a view to a common venture. And so it seems to me the second requirement is satisfied. The third requirement, that has been used to the detriment of the person who made the communication, that too can be said to be satisfied in this case. Accordingly, it seems to me the requirements of confidentiality are satisfied. Now, as one might expect, Mr. Murray has made considerable point of the fact that the use of this information to the detriment of the plaintiffs did not occur until after there had been a breach between the parties, after the report had been made about the easements, and both sides had in effect withdrawn from any further progress with the proposed transaction. And one question is, what is the effect of this break in the progress of the negotiations? In particular, can it be said that information acquired before the break is set free from the obligation of confidentiality once the break has occurred? Can it be said that in the present case there was, as was said in the Canero case, a fresh initiative, as Mr. Murray stressed, and that the discovery that the land had some commercial value due to the possible manufacturing venture of the Japanese, that was something quite new that came into the case after the break, and so it was not caught by the pre-existing obligation of confidentiality. For my part, I would reject that submission. What we have to realize in this case, I think, is that there had been this agreement, not a formal contract, but nonetheless an agreement on both sides that an investigation should take place by Miss Smith. Now, if there is an agreement that an investigation should be made, both on title and generally, for the purposes of this joint venture, and it could have been for no other purpose, then it does not matter that there was no formal relation of solicitor and client between the plaintiffs on the one hand and Miss Smith on the other hand. If you have an agreement that there is to be an investigation, there must also, it seems to me, be an implicit agreement that the result of the investigation will be reported to those who commissioned it. And furthermore, it seems to me quite essential, as Mr. Laskin submitted, that this obligation to report the result must be an obligation to report the whole of the result to both sides, and not part of the result to one side only. Without stressing the unfortunate error that was made by Miss Smith in realizing the ambit of these easements, a matter on which there is virtually no evidence before me, and one cannot possibly say how culpable or otherwise it was for her not to realize that there was, that she had made a mistake. It seems to me that there must be liability for not communicating the information fully in the first place, and secondly, for not correcting the information when the error was discovered. I do not see this as a single point of time when, once it is passed, all the obligations go. This seems to me to be a continuing obligation, and as a continuing obligation, the defendants are in breach. In any case, as Mr. Laskin pointed out, the inactivity of Interurban after the breakdown of the negotiations was caused by Miss Smith's mistake. Whether you call it negligence or what, it was her mistake that caused the negotiation to break down. Accordingly, it seems to me that Mr. Laskin has made out his case for liability on the score of misuse of confidential information. And on that ground alone, he is entitled to some judgment. But now the case was further argued on the breach of fiduciary obligation. That is a difficult subject. Indeed, the whole of this territory is difficult. And I would be reluctant to attempt to reach a decision on that if it were not necessary for the proper disposal of the case before me. One possible difficulty, I think, was disposed of by the Lack case. It was doubtful, I think, before that case whether the imposition of a constructive trust as a remedy was possible in the case of a mere breach of the duty not to misuse confidential information. The Lack case answered that question, and accordingly there is no necessary difference in the remedies available for the two different types of action as regards this case. Accordingly, I propose to say nothing about liability on the basis of a breach of fiduciary obligation, but to decide the case solely on the ground of confidentiality. Now, the relief sought is an injunction against the defendants, General Trust and General Developments, restraining the sale of the Bradford properties to the Japanese car manufacturer or any other party. I think Mr. Laskin would be well advised to amend that slightly to restrain the sale or other disposition of the Bradford properties, which at least would prevent a sideways transfer to another subsidiary. He asks also for an order that the defendants, General Trust and General Developments, hold the Bradford properties by way of constructive trust for the benefit of the plaintiff. And then there's a claim for damages. Now, those first two orders seem to me to be subject to anything Mr. Murray may have to say, seem to me to be proper orders to be made in this case, and I make those orders. The third claim is in the alternative, damages against all the defendants for breach of confidence, breach of fiduciary duty, and in the case of the defendant Smith, breach of duty of care. I take the words in the alternative that begin that clause to govern not only breach of confidence, breach of statutory duty, but also breach of a duty of care in the case of Miss Smith. And so accordingly it is not necessary to make any order under that head. Accordingly, I make an order under the first two heads of claim.
Obliged, my Lord. May I speak to the question of costs?
Yes, indeed.
May I respectfully adopt as my submission the submission so eloquently put on cost by my learned friend Mr. Murray, and may I say that the court may show its disapproval of the defendant's conduct by an award of solicitor and client costs in this case.
On behalf of my client, my lord, my client would like to thank you for the length of time it took between argument and the length of time of reserve you had in disposing of this matter. We're deeply appreciative of the great thought that has been given to our argument, and I have no further submissions, my lord.
You're not offering to pay for the great thought, are you? No, Mr. Laskin, I don't think this is a solicitor and client case. Ordinary costs.
Lord.
What are they?
Partway through Sir Robert Megarry's oral judgment, I passed a note to one who is highly regarded for his juristic talents in this jurisdiction, as Justice Creeper. My note said, "Is this what is known as a tour de force?" And he said, "Beyond question." We're most grateful to Sir Robert and to John Laskin and to Eric Murray. It was, as I foretold you, interesting, provocative, and entertaining. On your behalf, may I thank every participant in this year's special lecture series, and may I thank you for your kind and patient attention. 1990 special lectures are over.